training today is led by Ellen Davidson, staff attorney at the Legal Aid Society. We are so grateful to her for sharing this important information with you about what you and your clients can expect as you navigate the current housing landscape. And so, Ellen, with that, I will hand it over to you.
Thank you. Hi, I'm Ellen Davidson. I'm a staff attorney at the Legal Aid Society. I'm a housing attorney. I'm going to go through a bunch of slides and then happy to answer questions. And I think I've got the slide sharing in Zoom down pat, but sometimes things go wrong. So let's start with, okay. So I wanted to start with the fact that although we talk about the post-eviction moratorium, that we're in, we're post the eviction moratorium, and we say it as if there was one moratorium, there were actually multiple moratorium and multiple periods throughout the last 2 years. And to be clear, that even though there's been an eviction moratorium, there have been various victim moratoria, people have gotten evicted through most of this time period. Originally from March 20th, 2020, until June 22nd, 2022, everything was closed down. We all remember that time period. Everything was closed down, the courts weren't open, and no one could be evicted. But once June 22nd happened, the courts did reopen. And so at various points, cases started moving forward as of that date. And then from that June 22nd date until December 2020, there were a series of court orders and executive orders that covered and stopped most of the evictions that might have happened. Particularly in the fall of 2020, there was a fairly weak executive order that was in place that did allow people to get evicted. And then in December 2020, the state legislature passed the law that we refer to as our eviction moratorium. And that law put a stop to things happening for 60 days so that the new regime can be put into place, and then was extended in May and then again in August and ended in January 15th. And that was the moratorium that required tenants to submit hardship declarations to stop their case either from being filed, from moving forward, or from being evicted. And so that was our eviction moratorium. However, as I said, there was not just one law that protected tenants from being evicted, there were actually two. So we had the eviction moratorium law, which was part of the COVID Emergency Eviction and Foreclosure Prevention Act. That's what ended on January 15th, 2022. But our rent relief program, which we call Ewrap, was also created by statute. And that law said that while a tenant has applied for rent relief, but before the tenant hears whether or not they've been approved, that nobody's eviction case can move forward. And so if you're working with tenants who have applied for Ewrap and haven't heard yet, or they currently apply because the application process is still open, that will put a stop to the case for the arrears that they seek, the back rent that they seek. I will go into a little bit more what the Ewrap program is and who qualifies and what this means, but just I want folks to understand that while our eviction moratorium law ended, the protections in Ewrap remain in place. So what is Ewrap? Ewrap is a program that was primarily funded through federal dollars New York State received $2.4 billion. And in order to qualify the program, you have to be a tenant or an occupant who shows that they're obligated to pay rent, that there's someone, at least someone in the household who either qualifies for unemployment, had a decrease in income, or a significant increase in expenses. They have to demonstrate a risk of homelessness or housing instability, and owing rent is as much as you need to show a risk of homelessness. And household income has to be at or below 80% of area median income. The state did create a program for people above 80% of area median income, but they recently closed that program and transferred the money into other uses because they could not find enough people above 80% of area median income who needed the help. So as I said, upon application, everything in an eviction case gets stopped. And it's until a tenant receives a notification that they've either been approved or they've been rejected from Ewrap. One thing to say about people who've been denied Ewrap, they can appeal. There's an appellate process. And currently, the agency that runs Ewrap, which is the Office of Temporary and Disability Assistance, says on their website that if you're in the appeals process, that they read the law to say that the case can't move forward until there's a final determination on your application. With Ewrap, tenants can get up to 12 months of back rent and up to 3 months of future rent. You can only get future rent if you are rent burdened, which means that you pay more than 30% of your income towards your rent. If you aren't rent burdened, you can apply for back rent. You can apply for future rent. You can also, as part of your application, ask for utilities. But you cannot apply for this program or receive any money from this program if all you're doing is applying for either future rent or utilities. You must owe rent. So just so we understand what we're talking about, this is the data that's on the Ewrap website. So far, we've had over 300,000 people apply. They've either obligated or paid $2 billion out of that $2.4 billion. There's a significant amount of that $2.4 billion that is being used for administrative costs. So they basically run out of money. They've paid out 124,000 tenants' households. Money goes directly to the landlord. And the value of that payment, the payments that are currently in the hands of landlords, is $1.6 billion. There is, the law says that where a landlord has refused to cooperate with the Ewrap program, the tenant may be found eligible, and the landlord will be given multiple opportunities to cooperate. If the landlord continues to not cooperate, the money that the tenant should be getting gets put aside in a different bank account. The tenant is informed that they have been provisionally approved. The landlord is informed that they have 180 days to access the money. If they still refuse to cooperate, the tenant remains protected by the program. The landlord, though, can no longer seek the money from the tenant. So there's about 35,000 tenants who are in this category. They've been approved. The money has been set aside in a separate account, but the landlords have said we won't participate with this program for various reasons. The amount of money in that separate account is about $440 million. In November, there was over $1 billion in that account. So the agency certainly has been working with landlords and has been able to gain cooperation and been able to disperse funds over the last number of months. So right now we're at a place where Ewrap is open, but it is currently unfunded. There are conversations in the state legislature about whether or not to fund it as part of the budget. And there are opportunities for more funding from the federal government. Although thus far, we've asked for $1.6 billion from the federal government in additional funds, and we've currently received $27 million. So there's theoretically opportunities for us to get more money from the federal government, but thus far it's been very challenging. But there's a second law that was passed during COVID, which will also protect tenants who've been sued for non-payment of rent. And it's called the Tenant Safe Harbor Act. And what this does is, I'm going to take a step back and explain how non-payments work, because you have to understand it to understand why this act can be used as a defense in a non-payment case. When a landlord sues a tenant for non-payment of rent, what they are seeking is a possessory judgment, which means the court will say, yes, the tenant owes rent, and the tenant has, there's a judgment, a possessory judgment now against the tenant. If the tenant doesn't pay the rent, the landlord can regain possession by executing on the possessory judgment through the marshal process, where the marshal comes and actually evicts the tenant. The landlord can then go to small claims court and seek a monetary judgment for the same amount of money. And then the tenant has to deal with not only being evicted, but also having a monetary judgment. Both of these things obviously are very serious, right? If you have a possessory judgment, it leads to physical evictions, people losing their homes. Monetary judgments could lead to attaching of bank accounts, garnishing of wages, and obviously damaging someone's credit. What the Tenant Safe Harbor Act does, it says that if a tenant can show COVID-related financial hardship, the landlord cannot get a possessory judgment for the back rent. They can get a monetary judgment only. And the law directs the judges to look at whether, look at the tenant's pre-COVID income, during COVID income, liquid assets, and whether or not the tenant or occupant has been eligible for any government benefits, including unemployment and public assistance. Additionally, there are other laws that say that if a tenant submitted a hardship declaration, there's a presumption that they faced a hardship. And I think that any tenant who's received Ewrap, there's a very good argument that a government agency has looked at that tenant and determined that they have had a COVID-related financial hardship. The time period for this law is March 7th, 2020 until January 15th, 2022. To be clear, that's not when the law is in effect. The law continues to be in effect. That's the period of time when if rent came due during that time period, that the tenant can raise a defense for those months, which practically means that any tenant can raise that defense from starting, because most tenants pay rent at the beginning of the month, starting April 1st, 2020 through January 1st, 2022. But that defense can be used at any time in the future. The time period is specifically about when the rent became due. So what tools do tenants currently have to fight evictions? So New York City has right to counsel, and having an attorney be able to use the Ewrap stay, the Tenant Safe Harbor Act is incredibly important. I will tell you that the legal services programs are being stretched thin, but at the moment, if a tenant shows up at court, the tenant will be offered an opportunity for counsel. Tenants always have the opportunity to raise issues around conditions. There are other rent-arrear programs like one-shot deals that tenants can apply to pay for arrears. And as I said, there's the Tenant Safe Harbor Act. But there are some problems, right? Tenant Safe Harbor Act is only for a tenant who's in a non-payment case. If the tenant is unregulated and the landlord is evicting them because the lease is over, it doesn't matter how difficult COVID has been for them or what financial challenges they've had, the Tenant Safe Harbor Act cannot be used. And one-shot deals are loans. They're not grants. They require that the tenant not only have the future ability to pay their rent, but also the future ability to pay back the loan. Some of you may have heard about a fight for good cause eviction. So I just wanted to go through what the bill that tenants are fighting for. If you're a tenant who lives in rent-regulated housing, either rent-stabilized housing or rent control, or public housing, or affordable housing, tenants already have this right. This law is to protect tenants who are in unregulated housing. And currently, if you live in unregulated housing, you can be evicted at the end of your lease term because the landlord has decided not to renew the lease. Landlord does not have to have a reason. Additionally, if you live in unregulated housing, your landlord can double, triple, quadruple the rent without any justification. And I know tenants across New York City are seeing huge rent increases at this moment. The bill, the good cause eviction bill, if it becomes law, tenants could challenge large rent increases. The way the law works is it says that if a landlord increases the rent by a certain amount, and the tenant challenges that amount, the landlord would have to open their books and show that they actually needed the rent increase because of increased costs. Additionally, if a landlord brings what we call a no-cause holdover, the landlord would actually can't do that. The landlord would actually have to say, I'm evicting this tenant for a reason. Who's covered by this bill? It's all rental housing except for owner-occupied 3 or less units. So if you're a landlord and you rent out, you have a 3-family house and you rent out the other 2 units, you are exempted from this law. Studies show that actually if you're in an owner-occupied small building, those landlords tend to have their tenants stay, tenants tend to stay there longer and tend to have lower rents. And the reason for that is those landlords reward good tenants, while corporate landlords often just are very happy to get rid of any tenant, especially someone who complains. So what are the good causes for eviction under the bill? Obviously, non-payment of rent, nuisance, breach of lease, owner occupancy. If the building is less than 12 units, the owner can evict a tenant for because an immediate family member of the owner wants to move in. Failure to provide access to make repairs and illegal use. So as I mentioned, there is a limitation on rent increases in the bill, but it's not like it's not a rent cap like you might be used to in rent stabilized housing. It's a guide for the courts. It's actually what the law calls it's a rebuttable presumption. So if the landlord can show that there's a need for a larger increase, the landlord can raise the rent higher. The the guideline is 3% or 1.5 times the consumer price index, which is the index that measures inflation, whichever is higher. So right now we're talking about a 9 or 10% increase. One of the challenges about fighting for good cause eviction is that there's just a lot of misinformation out there. And so I have a couple of slides on myth busting. You know, you'll see landlords talking about that if they pass this law, tenants will never have to pay rent again, which is just inaccurate. It says it will discourage investment and prevent landlords from making repairs. There are good cause eviction laws in various cities and states across the country, and basically that fear has not been borne out. You hear that it will cause more eviction cases. The one study I could find on this, which was a study of cities in California that passed good cause eviction laws, and then compared those cities that had passed the law to similar cities that didn't have the law, and actually found a decrease in evictions and eviction filings in the cities with good cause eviction. We hear this will mean the end of development in New York. New Jersey has had this law since 1974, and they're in the midst of a construction boom. And then there is a concern that this will affect cooperators, people who are shareholders in co-ops. But this is actually a law just about people who can be evicted without good cause. And obviously you cannot lose your co-op at the end of your lease term, because there is no lease term that ends in co-ops. So I wanted just to talk briefly, and then I'll open the floor for questions about what's going on in housing court at the moment. So I put these slides together yesterday, and in fact, there is breaking news as of today. So a lot of housing court is currently virtual, and even with the breaking news, some of it may continue to be virtual. I put on here a link, and if you go on this link, it has every borough, and when you click the Bronx, for example, I just wanted to give people a way to see, it shows that if you want to participate virtually in a case, you have a virtual court link, and you have numbers and conference IDs for people to do that. People do show up in person in court. Oftentimes it's because they do not know how, like the information about how to participate virtually has not been shared well. So people sometimes show up because they don't know what else to do. The other reason people show up is that a lot of people don't have access to the technology which would allow them to participate in court. So they show up in court. Additionally, it's really important when tenants get housing court papers for them to respond. If a tenant gets a housing court paper for a holdover case, what they'll receive is a date and a time for that case to be heard. In New York City, if you receive a court paper for a non-payment case, the case does not end up in court on a calendar until a tenant answers it. And back in the day, the way tenants answered it is they would all show up in court and wait online for hours to get up to the clerk's office. Nowadays, they have other ways to help tenants answer petitions, so they don't necessarily have to appear in court. And so I gave you information on that you can share with people on how to answer petitions, and also help numbers. As of March 28th, according to the Chief Judge of New York City Housing Courts, more and more in-person proceedings will be returning. During the pandemic, a specialized courtroom has been set up for what they call small property owners. sadly, it's actually not targeted at small property owners. It's targeted at property owners who own small buildings. So you can be a corporate interest who owns, 50 one and two family homes, and you'll be treated the same as the person who owns one two family home. Which I think is a mistake, because the corporate interests are going to manage their way in this part better than the people who who the court is trying to help. But those cases in this small property courtroom are going to have to be in person. That's what the court said. And then all trials will have to be in person. Unless people ask for virtual hearings, and certainly people who may have medical needs and other disability-related reasons for needing to be virtual, can always ask the court to accommodate them. But as I said, this new directive about in-person proceedings was issued yesterday. I saw it today, so I think we're still going to be learning more as time goes on. So that's the end of my slide presentation, but I'm happy to answer any questions. I haven't really looked at the chat as I've been speaking, so I don't know, Tess, if you want to.
Some questions to run through, and everyone keep throwing them in the chat. All right. So would you mind sharing the steps for applying for a one-shot deal with Ewrap pending?
With Ewrap pending, it is challenging. So when Ewrap first came into being, the state agency decided that you could not apply for a one-shot deal until your Ewrap application was finished, which is a problem because, as I said, you can only get 15 months back rent. 15 months, 12 months back rent, 3 months going forward. And a lot of our clients, at least, owe more than that. And so we were really hoping that you could go through this dual track process. So at the end of it, the tenant will have the one-shot deal and the Ewrap together and be able to end cases. But the state agency said, no, you have to go through the entire Ewrap process, and then you can apply for a one-shot deal. So for the vast majority of people who've applied for Ewrap, that holds. If for some reason you are in front of a judge who has decided to move a case forward, even though you're waiting for Ewrap, and there are some judges out there that are doing that, that you may be in a situation where you can make the case to HRA that your one-shot deal should be considered. There's one category of people who can apply for both, and that is the Ewrap program closed its application portal in November, and then they reopened it in January. If you've applied since the closure, so if you started applying for Ewrap in January, you can actually apply for both one-shot deals and Ewrap at the same time. Additionally, we are told by the state agency that they are reconsidering their one-shot deal policy about the people who are sitting on the waiting list, but we don't know, they haven't said how what they're planning on doing.
Related to one-shot deals, are there ever any cases where someone does not have to pay back the one-shot deal?
Yes, on a practical basis. So if you're someone who's judgment proof, and people are judgment proof who are on Social Security, they can't, even if the agency went out and got a judgment against them, it can't be executed on because you're protected by Social Security income. You know, the agency sometimes will work with tenants and say, as long as you're paying back a tiny amount, we're not going to move forward on the collections. I will say we at Legal Aid have spoken to legislators, and there's a bill that's being carried by Senator Kavanaugh and Assemblymember Rosenthal, which would make one-shot deals during the COVID period into loans. Into grants, not loans, so they wouldn't have to be paid back. But that's a problem with the one-shot deal program.
Right. And for people who apply for Ewrap after the application had closed, is it better to apply for a one-shot before or after you receive a court notice for non-payment?
Well, if you're currently someone who's applied for Ewrap, and even after the portal reopened, you shouldn't have a case that's moving forward, because by applying, it should stop your case. And if you have a tenant who applied for Ewrap and their landlord then filed a case, they should contact their landlord and tell them that they can't move forward because of Ewrap. But whether or not it makes sense to apply for a one-shot deal at the same time, it's a very individual determination. Mm-hmm. I will say that to the extent so for Ewrap, if you are a subsidized housing tenant or public housing tenant, you are at the back of the line. Everyone else is going to be paid Ewrap before they get to you. That was a decision the state made, which I think I disagree with, but you know, I didn't write the law. There may be some situations where you have people who maybe have Social Security income, so they're judgment proof, and they're in subsidized housing. And so they have future ability to pay their rent because their rent is set at 30% of their income, which is the definition for future ability to pay. And so they don't owe a lot of money, and they're a subsidized housing tenant, and they're judgment proof. It may make sense to apply for a one-shot deal and just have the case over with, instead of waiting around to see what happens with subsidized housing tenants. But as I said, these decisions are like, there's no rule of thumb. It is a sitting down with someone and figuring out what makes sense for them.
So I have a question that I think, you know, we've heard a lot done a number of trainings about Ewrap. What do you do if the landlord does not want to accept the Ewrap application or payment?
Yeah, so the law is very clear that if a landlord doesn't accept the Ewrap payment, that the tenant is still protected for the money that would have been covered for the Ewrap payment. So let's say a tenant, all the money that is owed is the money that would be covered for Ewrap. That makes things easier. The landlord says, I'm not going to accept it. The tenant will get a notice saying your landlord wasn't paid because your landlord didn't cooperate, didn't want the money. Mm-hmm. For the first year after you get the notice saying you're provisionally approved or you've been approved, you can just show up in court and show the judge that notice. It's like a complete defense to the landlord seeking that money. If the landlord wants to be tricky though, and wants to wait in hopes that like you lose the notice or people forget about Ewrap, they have a year to seek the money. If they don't file a case against the tenant within 12 months of the tenant being approved for Ewrap, then the law says they've waived that money. They've basically by their actions agreed never to seek it. So tenants are protected, and most judges know that in New York City. And I did see somewhere someone saying, I'm in Westchester, we represent both people. Some landlords understand that in Westchester. There's a lot of judges in Westchester in different courts, and I'm hearing feedback that some of them understand the law and some of them don't. I see a thing in the chat saying that Ewrap, someone says they have a client who said that their application was denied because Ewrap has no more funds. That should not be a basis of denial. That person should appeal. But it is true that there are no funds at the moment. There are 2 avenues to get more funds, and we should know more in April about whether the state is successful in either of those avenues. But at the moment, the agency is not denying anyone because they have a lack of funds.
Okay, important information to know. All right, if you have a tenant that does not have a social security number, would they be affected by monetary judgments?
It's hard to imagine how they could be.
Great. And if a lawyer is representing a tenant or a landlord, are the clients still able to log into the court proceedings if they have the link, or is that something only the attorney can do?
No, the tenant has every right to be participate in their own case. So they absolutely can log in with the link. They should have a conversation with their attorney. But you know, I think most attorneys would encourage their clients, if they want to participate, because it's the client's case.
Right. Looping back to our previous question, how do you appeal an Ewrap decision if you get denied?
You can call the number. Well, I'm sorry. There are instructions on the OTDA website. You can do it, I think, in 2 ways. One is you can call the number, and there should be information on the notice about how to appeal. But you can call the main helpline number, and you can also upload documents on the case.
And in our follow-up, we'll share some of those links and numbers and emails so that everyone has them in one place. Okay, one moment. So if someone applied for Ewrap, but somehow the necessary documents were not submitted on time, what should the client do?
If the client hasn't submitted the documents but hasn't yet been denied for Ewrap, they should submit the documents now. If the tenant was denied and they've been denied because they didn't submit the documents, I mean, they can try by applying again. Theoretically, they can apply again. They can also try to appeal, but the agency has told us that they are taking the position that if the reason for the denial is that the tenants didn't provide the correct documents, that even if they submit them as part of the appeal process, that they will consider their original decision to have been correct. So you know, the tenant could try to, it might make sense if the tenant has all the documents and that's the only reason they were denied, it might make sense to try to do the application and fill it out completely.
Okay. So Ewrap has said that if you are living in subsidized housing, your application will move to the back of the line. Is the tenant still protected even though their income has not changed?
I don't think I understand that question. What is that?
I'm not sure. If you ask that question, feel free to throw some clarification in the chat or unmute yourself. In the meantime, is there protection against eviction? Is protection against eviction dependent on the number of units in one building? Like 6 units or less or more?
It really depends on which protection, but for Ewrap, no, it doesn't depend on the number of units. However, if your landlord accepts Ewrap, There are some protections that come along with that acceptance of Ewrap, which include if you're an unregulated tenant, your landlord can't evict you for that reason for 1 year. Like you can't evict a tenant for the reason that their lease wasn't renewed for 1 year. If the landlord has accepted payment from Ewrap. However, if the building is 4 or less units and a landlord says that they're evicting the tenant because they want to live in the apartment, then that's the difference. Is you don't get there is some exceptions for those Ewrap protections if you're in a building that's a small building and the landlord says they want to move in.
We just got another one in the chat. How can we proceed when a case is renting from another person where there's no landlord? Like if you're renting a room from another person.
So that's a really complicated situation, and the answer depends on whether or not the landlord, the person who's the property owner, is owed money or not. So in a situation where you have a tenant who's renting out part of their apartment, or a subletter, right? Like a tenant who doesn't live there and is renting out the apartment. And the agreement is between the roommate or the subletter and the tenant. And the person who is the person who is owed the money is the tenant. The agency will not pay that person, right? The agency says that they are only paying property owners, and they will not pay tenants. However, if the person, the tenant, the person you're renting from, didn't pay rent to the landlord, you can apply and have not the tenant, but the landlord say, yes, money is owed, and Ewrap will pay in that situation. So, it is better to do that application with the tenant of record, and you can do, you can both apply together, but it doesn't have to be.
Okay. And then, okay, I think we had a response to that in the.
Oh, if the right, sorry. Okay, so I see the building is, so when I say subsidized tenant, I mean project-based Section 8 voucher, or public housing. Rent stabilized housing is not actually subsidized, and their application can move forward if there's no subsidy. However, if someone is in this category that gets moved to the back of the line, they are currently protected from the eviction case moving forward because everyone on the waiting list is protected.
And in the case of rooms being rented out, oh no, sorry, go ahead.
Yeah, in the case, so yes, absolutely. If in a case where rooms are being rented out, if the person on the lease, who's not the property owner, is that person allowed to take the person who rents a room to court for non-payment of rent? And the answer is yes.
So if someone applies for Ewrap today, do they have the same protections as someone who applied for Ewrap when funding was available?
Yes.
Great.
And so I'm waiting for a response from Ewrap. When are they going to start sending responses? So we are still getting some approvals, not a lot, some approvals. The cases that they are processing are those that were people applied for before September 21st. If you applied after September 21st, I would not expect to see a response for a while. There are two possible places where more funding may come through. But neither one is happening immediately. That's why there's going to be a little bit of delay. The first is that the New York State is going through its budget process at the moment, And both the governor and the legislators have suggested that they are interested in using some federal relief money they received to put into the Ewrap program so that there will be more money. The governor mentioned that they had $2 billion to play with. The $2 billion, frankly, she mentioned like a million different uses for it. I don't know whether she's going to use it for Ewrap. Next week, both the Assembly and the Senate will come out with their budget proposals, and I do expect to see money in both proposals that would be directed toward the rent relief. In addition, the federal program that set this up was, as you might imagine, it's like throughout the nation, right? That the money was allocated. Lots of different, all the states got money, lots of localities got money. And the statutes that created the program also created a way to reallocate money from places that haven't used their funds to places that have used their funds. There's a lot of money out there. Thus far, the Treasury Department has not been good about reallocating money between states. I imagine there's a political, they think they'll have a political problem. The next phase of the reallocation happens after March 31st. And so there's also the possibility that the federal government will provide us with more funds. And so that's part of the reason why the applications are still open, because there's a chance that we will be seeing more funds to fund the applications on the waiting list.
Thank you.
Are there any protections when a landlord decides not to go after a tenant based on the owed money, but pursues a housing court eviction based on an expired lease? You know, if the court papers that the landlord submitted says, I'm evicting this tenant because of an expired lease, but I also want my back rent, and the tenant applies for Ewrap, that should delay the case. But the reason we call these expired lease cases no defense or no cause evictions is that there are ways of slowing this down, but there are not ways of stopping this. There aren't any defenses, frankly. To the extent the person owes money and applies for Ewrap and gets paid by Ewrap and the landlord accepts the money, the landlord can't move forward on this type of case for a year. But some landlords, we think, are going to just say, I just want to get rid of the tenant and I'm really angry because they didn't pay, and we'll move forward with these cases. Illegal basement apartments. Yes, a landlord can take you to court to evict you. It would, but the landlord actually wouldn't be successful. The landlord if a landlord brings you to court for non-payment of rent, there's a defense if you live in a legal basement apartment, because they really shouldn't be renting you the apartment. The landlord can bring you to court on a no defense holdover, absolutely. But frankly, it is quicker for landlords to just call 311 and have a housing court, HPD inspector, the housing department inspector, come and vacate the apartment. Tenants who get vacate orders on their apartments because they're illegal basement apartments do have some rights to shelter through HPD. The good thing about HPD shelters is that they are more likely to have a path to permanent housing than regular shelters. There are certain obligations HPD has to help someone find permanent housing.
Okay.
And in this particular case, with the basement apartment, Ewrap already paid. Yeah, I mean, if a particularly bad landlord will just call and they do this all the time, will take the money and then kick the person out by calling 311. And landlords don't really get punished for renting out illegal basement apartments, and they don't, they get away with a lot.
Yeah, it's brutal. Well, I have a couple questions that came through, just sent to me. How is a one-shot deal calculated when Ewrap is pending and additional arrears are owed prior to the COVID period?
Again, I don't know that I can answer that question. That's really a question for HRA.
Okay, great. And then someone emailed me asking about, we talked about like good cause eviction legislation and things like that. Will there be any help for people who are undocumented?
Yeah, that's a great question. So one of the pieces of legislation that we're working hard for in Albany is called, it's a bill called a Housing Access Voucher Program. And it's a program that is modeled on the federal Section 8 program. But one of the benefits of having a state Section 8 program is you can make whatever rules you want to about immigration status. And so one of the things about this program is it would be available to people without immigration status, unlike a lot of the other programs that are out there to help people. Yeah. I see this. If I applied in October and the application isn't reviewed, would that be the year? It's the year that the landlord agrees not to evict for non-renewal of the lease starts from the date of the approval notice, not the date of the application. Ewrap is still open for tenants. If a tenant hasn't paid since 2019 and their income was not affected by COVID and they continue to refuse to pay, they don't really have protections. I mean, they have the same sort of due process protections that anybody has, like the landlord has to give them notice before bringing them to court. They still get to go to court. They will have an attorney, but they will be evicted if they're if they're not paying, they're not affected by COVID, and they haven't applied to pay the rent. Other than housing court answers, who else can we contact for questions about housing court processes? If you call the 311 and say you want to talk to a tenant hotline, all the legal services programs have hotlines, and you will be connected to someone where you can ask questions about housing court processes.
Great.
Can a landlord file both a non-payment or a holdover? So the answer is theoretically no. And the reason is that it's technical. It's if you file a non-payment case, you're saying if the tenant pays me, the tenant remains a tenant. And in a holdover case, you're saying I don't recognize this person as a tenant anymore. So those two messages are contradictory. And so you can't maintain both cases. It's not unusual to see a non-payment case be converted into a holdover or vice versa if it makes sense for that particular case. But the landlord basically has to decide which path to go on.
We got a question a little bit ago. I'm not sure if you answered it. Someone said, what about LRAP? What if the landlord applied to LRAP and is still insisting that their client pay their arrears?
Yeah, so LRAP so LRAP stands for Landlord Rent Assistance Payment. And remember in the beginning, I said that it was at the very beginning that the there had been a rent relief program that was created for people over 80% of area median income, and it didn't get a lot of applicants, and the money was moved. At the same time that the state created that program, they created a program for landlords called LRAP. And it was theoretically for landlords who either had tenants move, because you have to currently be living in an apartment to apply for Ewrap. You can't apply for an apartment you moved out of. So it was for landlords whose tenants had left, and it was also for landlords whose tenants refused to apply for Ewrap. If the landlord applies for LRAP and receives the money, they should not be seeking the rent from the tenant, because that money will have been paid. However, that program ran out of money and closed down in November. They have gotten some additional money that was from the over 80% of area median income. And I fully expect that we will see more money in the budget to go to that program. So if the landlord is on the waiting list and, but hasn't received their money, then yes, they can absolutely go after the tenant for that money because they haven't been paid. But if the landlord was paid and is double dipping, they want both from the tenant and from the state. I mean, that's not legal.
Okay. Sorry, did you answer the question in the chat? Can landlords file both non-payment and holdover?
I did, unless it was confusing, and then I can try to do it again.
No, you're good. I'm just reading a bunch of questions right now. And who do we contact about double dipping?
There on the Ewrap website, there is a place to report fraud. And that's, there's like a report fraud. I think even if you go on their main page, when you look at the left-hand side, there's a menu of places to go, and one of them is report fraud, and fraud should be reported.
And we'll try and send that specific part of the website in our follow-up email. Yeah. All right, any other questions? Anyone? While we're waiting to see if anyone has any more questions, I've entered a few things into the chat. One is a short survey to provide us with feedback about this training, and to identify other topics that would be of use to you all. So please fill that out so we make sure we're getting you guys the right information. And we have 2 upcoming consortium events. Next week, a training on Medicare resources and the Medicare Advantage open enrollment period, which ends March 31st. So now is the time to enroll. And then on March 22nd, we have our consortium biannual membership meeting. If your organization is a member of the Health and Housing Consortium, we invite you to join us to hear about what the consortium is working on, hear about what your needs are, and how we can work together. Any other questions? All right. Ellen, thank you so much. I know we had a ton of questions, and we really appreciate everything that you shared with us. We'll be following up with the recording, the slides, and all the various bits of information and resources that were shared during this training. And yeah, thank you to everyone who attended, and thank you, Ellen.
Bye-bye. Thank you for having me.
Have a great day.